Hey everyone, and thank you for watching. This is Erica Macias with Barrett Co Inc Realtors, and today I'm so excited because we are having our quarantine morning chat and coffee with our host for today, who has how many years of experience?
30 years.
Wow, 30 years. Senior over here. In the
Hopefully I look only 30.
Yeah, so our host for today has 30 years in the title and escrow industry. She was also the president of the Escrow Association of Nevada, Miss Madam Toastmaster as well, best presenting speaker, Jennifer Smith with Lawyer's Title. Jennifer
Oh, thank
Smith
you.
is a senior escrow officer and team branch leader at Lawyer's Title. I've had the honor to work with Jennifer Smith for the past 14 to 15 years. I originally met her when I worked for First American Title and attended the National Escrow Association because once upon a time ago, I wanted to become an escrow officer.
Oh.
I wanted to be an escrow officer assistant. Back in the day, just being an escrow officer assistant was just so cool. Everybody, I don't know, when you're in the title industry, that was like the next step up for me. However,
Yeah.
I never went there. I stood in title. I stood in my lane.
That's funny because we were talking about staying in each other's lanes.
Right.
Attorneys.
Yeah. And Jennifer Smith also is a valuable person in a escrow transaction when you're buying or selling a home. And I'm so happy to have her a part of my team. So thank you so much, Jennifer Smith, for your time. And please give her a round of applause for Jennifer Smith. So do you want to go ahead and introduce the topic of what we're going to be talking about today?
So what we're talking about today is about how to basically avoid probate and different ways to take vesting and how probate and different types of deeds can affect the sale of your property.
Yeah, so I'm so excited. Jennifer is giving us the hidden secrets that only senior experienced escrow officers know. So you guys are really in for a treat. And thank you so much, Jennifer, for taking the time. And we will get to our presentation next.
Thank you, Erica, for the introduction and allowing me to be part of your team. I think that who you partner with matters, and I'm glad to be a partner with you.
Thank you.
So what do you need to know when your seller is deceased? It's very common that I have at least 2 or 3 transactions where a seller is deceased, and believe it or not, sellers or agents don't know what to do, what's to do next. So I'm here to give you guys a little information about that. Maybe. I think my computer is frozen. So today you'll learn about different ways on title where probate is not needed. And then what is needed when a trustee is deceased. What is a deed upon death and what items are needed when a deceased parties execute upon a deed upon death. And what probate is and what you'll need to go through probate. There are different types of vesting. We have joint tenants, where it could be husband and wife as joint tenants, it could be sister and brother as joint tenants, or unmarried parties as joint tenants. And we're going to show you a flyer about different ways of taking vesting. We also have community property with rights of survivorship. That is only married people can take title as community property with rights of survivorship. And then tenants in common. Tenants in common are where individuals take title, and that's 60-40, 70-30, 50-50. And then you can also take title in a trust, and then as individual. Adrian, I can't remember when you and Kim did this last week. There was one more way, and I could not remember which way. So if you can remember, let us know. There was something that you guys said in class. So what does escrow need to close when one of these vested parties become deceased? So when you are entitled as joint tenants, or when you have sellers who are entitled as joint tenants, you just need a death certificate and an affidavit terminating joint tenancy to remove the deceased interest. The death certificate has to be the original death certificate, and that's with the raised on the certificate. Or you can see kind of like money where you see the lines through, that was issued by the county. Each state has different forms of death certificates, so we definitely need the original. Usually when you have elderly people who don't have the death certificate, they will have to order it from the state from the, what is it, vital statistics, to get it, just the same as birth certificates. So just keep in mind of that when you're taking a listing and you ask that question, where is your spouse? If the spouse isn't there, oh, we need a death certificate. Oh, where do I get it? When you're on title as community property with rights of survivorship, you'll also need a death certificate and an affidavit terminating community property. And these documents are documents that the affidavit terminating joint tenancy and affidavit terminating community property, the title company actually has those documents, so you don't have to search for those. And then when there is a trustee who's deceased, we would need a copy of the trust, the death certificate, and we would prepare the certificate of incumbency or affidavit terminating the trustee.
Jen, I have a question.
Uh-huh.
Okay, so the certificate of incumbency, are those still being recorded, the original documents down at the recorder's office? How is that being done now? Is that something that you can upload through Simplifile?
Yeah.
The death certificate and
Yes. So the death certificate, when you try to make a copy of a death certificate, on the back it says void, 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 void if copied. So our copy machines actually can remove those voids, but we do need the original, and I do need to make a copy of it. So you can't send a copy of it. Oh, well, here's a copy, because it has voids on the back of it. So, and I can get it recorded with the recorder's office through our electronic recording.
Okay. Diana Hillis has a question. She's saying the affidavit, what does it have in it and who has to sign it?
So the affidavit terminating the joint tenancy or the community property has stating that the deceased, or let's do this, the survivor is affirming that the person who's on title, the party who's on title, is deceased. And it is the person, usually the person who is the survivor of the joint tenancy or the community property, will execute that document. Does that answer the question? Okay. And if somebody's on title as tenants in common, that's where, since you don't have that joint tenancy or community property, you would have to probate that interest out. So that 50%, 60%, 40%, you would have to probate that interest out. And usually for estate planning, people do that so that their heirs can inherit the properties. So. And then if somebody's on title as an individual, then they would also have to probate their interest out. Okay. I see a lot of those.
Jennifer, this is Crystal. I have a question. If somebody holds, say, a property in trust and they get married after, does the trust supersede community property?
The trust does, if they're on title as the trust, yes, the trust does. So my title department is not going to ask for a spouse to execute a community interest, because this trust is in place on the property, not individual.
Thanks.
Trust is an entity. Okay. So now we're going to move on to deed upon death. I can't see everybody's hands, but who has heard of a deed upon death? Adrian, is there a lot? You're on mute, so I can't hear you. You're on mute.
Oh, I'm sorry. I'm clicking between everyone's screen and like looking for hands. No, I thought I saw one hand, but we have a lot of video that's off too. So
Okay.
Tell us about a deed upon death.
A deed upon death, what that does is that it avoids the probate issue, or action is a better word. It avoids probate. Not every title company will accept a deed upon death to transfer title. And then we actually have certain requirements to accept, and I'm going to show you what that is. So first of all, when somebody executes a deed upon death, when an owner executes a deed upon death, their intentions, I think the original intention is so that the person also would be able to have ownership of the property, and not intending to sell the property immediately, because there are certain requirements that we will have. Number one is it allows, well, first of all, it allows the owner upon death to transfer title to a named beneficiary without probate. And this deed can be revoked at any time, which means that if somebody wanted to refinance, or you know what, they had a falling out and you don't want to have this party on your title any longer, then you can revoke it. So like I said, that what do we need when there is a deed upon death? There are certain requirements, and our underwriter, our state underwriter, will have to approve it if we were trying to insure the transaction within 36 months, 3 years after death. I'm going through one right now where my friend's brother did a deed upon death and to her, and she's immediately selling the property. So we will need a zero demand from Medicaid, and I think Adrian can share that slide real quick. So Medicaid is kind of like the IRS. If there's anything that's owed, then Medicaid wants their portion. And so we would ask for a zero demand, and this is what it actually looks for. So this is from the state, and it shows, please be advised that the above decedent was not recipient of Medicaid. Therefore, oh, sorry, something popped up. My slide, your slide is gone, Adrian. So therefore, we did not need to pay Medicaid. If it actually has a balance, then we would pay that balance. So my friend who I was just telling you about, her brother owed $17,000, so we'll have to pay that through Medicaid. Okay. And then the next one is what we would need. Adrian. I think Singh has a question. Let me answer that real quick. He says, what if both husband and wife are on title, but the deceased person was on the mortgage? In that case, no deed upon death recorded, not intending to sell immediately is the first one. So if husband and wife were on title and the deceased person was on the mortgage, and let's just say the wife is the survivor, she would, that's why I think most people are doing the husband and wife as joint tenants, so that they still have the ownership. The mortgage company could call that note due and payable, just like a reverse mortgage. They're calling notes due and payable. My friend's brother had a reverse mortgage. She notified them that he is deceased. Then she notified him that he was deceased, and they're calling the note due and payable. If the wife notifies the lender, hey, my husband is deceased, they have the right to call that note due and payable. Okay. And then if they are going to sell it, then we just go through the process and notify the lender and get a payoff demand statement.
Can you see this?
Yeah.
Okay.
Yeah. And then Erica just asked a question, how do you revoke a deed upon death? There is a document that you can record, which is a revocation of the deed upon death, where it just states that you are revoking the beneficiary from that deed. So, and then we'll get the flyers out to you too for the most commonly asked questions.
Perfect.
Okay. Are there any other questions? Okay, perfect. Then the next one is, so we will need the deed upon death affidavit. So there's an affidavit that states that, yes, they have the right to own the property, and there's no heirs, there's no other outside bills, and it would be notarized. It could be notarized at closing, but it would need to be completed prior to, so our underwriter can approve it. And Adrian's going to show that one. This is a death of grantor affidavit that will be recorded, but here's the affidavit right here. This is what the form looks like, and just again certifying that the deceased is deceased and that you are the actual beneficiary of that property through the deed upon death. Thanks, Adrian. And then if there's a will, we'll need a copy. We want to hear from the decedent that, yes, he intended on transferring that title. She intended to transfer the property over to the beneficiary. And of course, we'll need a copy of the death certificate, same as before, the original certified copy. And what I have to provide to the underwriter is a closing statement. So once we know if there's a mortgage and any other bills that are owed, then I submit it to the underwriter, and with showing how much money that the property is going, the estate is going to receive, then they will make a determination on if they're going to insure the property. So remember, the Fidelity brand, Lawyer's Title is a Fidelity brand. The Fidelity brand, what we call the title group, we're one of the only title companies that will go through the steps to provide title insurance on this property when a deed upon death is issued. Some of the other title companies, their underwriters will not touch it if it was within 36 months, 3 years of insuring the property. I had a transaction a few years ago. I was at another title company, and people don't understand, like I said before, that people don't understand that, hey, I inherited this property, why can't I sell it? Because we are ensuring to the next parties that this property is free and clear, and there could be some liens that haven't arisen, but we are going through these steps to make sure that, hey, if there's anything out there, we want to know about it, and you need to let us know. And you're basically swearing that, yes, this is true and correct, because if not, we can come back to that beneficiary and ask them to pay if we have to defend that title. So, are there any questions there? Now the biggie. So the next thing is, if somebody dies without having a will, or even with a will, the property is going to have to go through probate if you didn't do a deed upon death, if you didn't have a trust, and if you did not provide the proper vesting. That's why vesting is so important, is because if you are on title, if people doing refinances and transferring title to spouses and not adding that vesting behind it, then there could be probate. And we've seen that. I've been doing this for 30 years, and we have seen it where people are like, oh, well, there was supposed to be a vesting behind there. We're supposed to go as joint tenants, but maybe there was a mistake and somebody didn't put the joint tenants or community property with the right of survivorship. And now the property has to go through probate. So what is the difference between testate and intestate? If you've heard of those terms before. So, and I always get them confused, so I am going to look at my notes. When somebody dies without a will, I'm going to make sure, sorry. Oh, there it is. When someone who dies without a will, it is intestate. When somebody who dies with the will, it's testate. What is a public administrator? When somebody dies without heirs, then a public administrator will be assigned to the probate case. So very important, because when somebody does have a will, then there's executors that are named. So do you see that question, Adrienne?
That was me. There's one, I just posted a document in the chat just to see if it would come up. So there's a document there. And then now Erica's asking about how much does a probate cost?
Good question. So my probate attorney was supposed to join today so he can kind of explain, but I have issued checks to him from $5,000 to $20,000. I think it determines or depends on the estate size. So, and then I think I answered this already, was what's the difference between an executor and an administrator? And that is, the executor has a will, or the estate has a will, and he has identified the executor, and then the administrator is appointed by the court. And so, secrete, if I said that right, just having a will doesn't mean you avoid probate. That is correct. You still need a deed upon death, vesting, and trust, all things, to avoid probate. That is correct. A will just determines how the estate is going to be distributed, but it still has to go through the court, so the court can make sure it is done correctly.
You have one more question in there.
Okay.
It says, is that paid up front or does it come out of proceeds? Not everyone will have that up front.
Usually it comes out of the sale. When I have done the transactions, I have some stories. So, but the attorney that I work with, I know that he knows that the properties are coming to him and that he's handling the probate. And I have seen where he collects it all through the proceeds. Does that answer your question? So, understanding probate. What are the steps to a normal uncontested probate? So I'm just going to do some bullet points. I am not an attorney, but this is what I do know of probate. So Erica has her hand up.
Oh, I've heard too, like of people tell me that there are some attorneys too that won't like have the cost come out at closing. They want them to pay up front.
Correct.
So not all attorneys.
Yeah, and I have an attorney that went, or I have a real estate agent that had a friend whose, whose client passed away, had 5 properties, and she went to 3 different attorneys, and they were like, I want this up front, I want this up front, I want this up front. And my attorney is like, no, I'll do this. There was circumstances where the mom lived in Thailand, but she had to go to Canada to be able to start working these papers, executing these documents. And so he knew that she didn't have a lot of money, but the estate, some of them were owned free and clear. So he knew the value of the estate. And so he waited, was about 6 months, and then he got his money. So, okay, so what are the steps to normal uncontested probate? Let's see. First of all, we need the death certificate of the decedent. There is a will that's delivered to the executor or the court clerk, and the attorney will handle these. There is a petition that is filed for the probate or will or letters of administration. So the attorney then files these letters of administration or the will. The letters of administration is stating the desires of the decedent, or now the heirs or maybe typically the heirs are saying, hey, this is my property. These are, what should be left behind. Because remember, when you have an administrator, the administrator is taking over because there's no heirs, okay, or not defined. A hearing is held on the petition. Good question, Jeff. It depends on the backlog of the court. I'm sure after we are cleared to work again, I'm sure it's going to be a very long time, because typically I've seen from 30 days to 60 days. But now with the judges, I don't think they're hearing the probate cases as quickly as they have been in the past. So I'm sure that it's probably going to be about sorry, I'm reading the questions. I'm sure it's probably going to be about 60 to 90 days now. And then Crystal said, I have only went on Fridays. And that is not the filing, that is the actual sale when there's a court order. And we'll get to that in just a minute. So the hearing is held on the petition. So what should you do when you list a property in probate? What should you do prior to listing? Okay, Diana, give me a minute on that question, and then we'll get to that. So letters of administration are issued by the court. That is just stating who the heirs and how the property should be distributed, especially when you're starting that listing process. And then notice of letters are given to the creditors, because we want the creditors to be able to determine, hey, how much is owed. Believe it or not, we do have to write checks to creditors. There is an inventory and appraisement of the estate made by the independent probate appraiser. And then they also have to still file taxes, because taxes are still due. And then there's a final accounting and petition for the distribution. So my attorney, when there is an administrator, he actually takes the proceeds and puts it into his account. And then he does the final accounting. So that's either to the creditors and then to the heirs, he distributes the funds and also his bill. And then a final decree of distribution is handled. And then there's a discharge of the personal representatives. So then they have no more responsibility for the estate. So can the property be sold when the property is in probate? Yes. So Diana's question is, what should you do when you list a property in probate? You first ask the question, is it in probate? Okay. Do you have an attorney? Get the letters of administration, and then you can list the property, because you want to know that administrator or that executor has the right to execute upon for the estate, because that is huge. Because if son says, hey, I have the right to execute, but the other son is saying, no, I have the right. You need documentation, just like a trust, just like an LLC, just like a partnership. You need the proper authority who is going to execute upon that listing, okay? Because that's really important, because if not, then you don't have a transaction. So I did have a transaction where you'll see a bullet point of proper documentation, proper orders. So the sons, sorry, I'm just trying to remember the story. The sons were the administrator. One son had more of the right, which he was here in town. The other son was in New York. And the court said, hey, son number one can execute. Well, we needed the flow of the documentation. So what the realtor did was the realtor said, hey, son number one, you are the only one that needs to sign. Well, it came out on the administrator as letters of administration that both sons needed to execute. The buyer, who was an agent as well, canceled the transaction because he said, well, we didn't have proper documentation, or we didn't have a proper contract because not all parties signed. So that was a way to back out of that transaction. So just know, when you're looking at your document, you can send it over to us. I can send it over to my title department, and my title department will say, John and Jeff have the right to execute, or John only needs to execute. And then that's how we're going to rely on our documents to be able to close on a transaction and ensure the transaction. So, and then what should you do prior to the listing? Let's see, and how far into this process? Usually, Diana, you either are starting or in the middle, okay? Because some people don't realize that they need a realtor, or they don't realize what they're going to do with the property. So I have transactions where my agent is from the beginning of when he's notified that somebody has passed away. He's in that transaction, and then the attorney gets everything. Some people are in the middle, like I said, and hey, we need to sell this property, and the letters of administration has been issued, and now the property is just in probate. Just because it's in probate doesn't mean that it's going to sell. And that's the next question, is if there's no will, how is the property of the estate distributed? It will be distributed through the court order, okay? And what I mentioned earlier, through the distribution of the assets. So the court will determine, and that's why you go through probate, is the court will determine how the properties are going to be distributed. So once the court actually determines that the property is going to be distributed, then there is a court order confirming the sale. And that's what Crystal was mentioning, that she's only went on Fridays. The court order confirming the sale is kind of like an auction, right? Because the court is determining who can bid on the property. So they're determining, hey, let's get the biggest amount of the purchase price that we can get, and let's put it up for auction. So if somebody bids $5,000 more, we can give it to that buyer, and now that buyer is the property. So one of the things that from our last class is that you should be, if you're representing the buyer of the property, when it's a probate case, you need to be at that auction on Fridays, okay? When they say, hey, by the way, the property is going to confirm the sale to your buyer on Friday, you need to be at that auction so you can bid if there's somebody out there that's trying to outbid you, okay?
We have a hand up. Crystal has a hand up, and another question from Diana.
Okay.
So in my case, when I did mine, my client was buying a property in Henderson for $350,000. And when we got there, I went, of course, with my clients, and there was multiple people there. And in order to get the actual court date, you have to have an executed contract, but that doesn't mean the court will approve it. Mine luckily was accepted, but there was multiple people that had contracts signed and still lost it because of $5,000. And that person didn't have a signed contract, but the judge allowed them to purchase it instead. So it's kind of cutthroat in there depending on your price point, because we were at $350, and at that time, I think the average price home was like $250, or it wasn't as high. It was easier for my clients to get it because it was in Tuscany, versus the people that were like $200,000 homes. They were getting outbid left and right, like cash buyers.
And then Diana has, with everyone else needing to be paid, where in line is the realtor? So when you've done the contract, the attorney understands that you're to get paid as well. So in that order confirming the sale, he will list all the expenses, including the realtor's commission. So in the final court order confirming the sale, he states the commission that's going to be paid. He states the closing cost, and he even estimates, and if there's a payoff, he also states that as well.
There's a certain percentage that they only go up to, that they pay out, and I don't think they pay, oh, I think they do pay a broker transaction fee.
Yeah, they pay broker transactions fee. Yep.
And I was going to say too, like along of what Crystal was saying, is I have handled like quite a few probate cases, and it amazes me that I don't see realtors at the courthouse when I'm there. They're not there representing their clients. So actually, out of all of them, only one has been there. So yeah, good for you, Crystal, for showing up.
Yep. Diana is asking the question, what if the estate doesn't have that much available? Well, as the listing agent of the property, you're going to have to determine along with the attorney how much the estate has. So, I mean, that's just something I've seen probate where there's a short sale, and yes, the attorney did get paid on that as well. So you have to determine if you're going to do a short sale or who's going to be owed on that. So of course I have some horror stories. I did have a probate that was involving a FRIPTA deal. It was a cash, or he owned the property free and clear, so he didn't have a social security number. He actually left the estate to a charity, is what he wanted to leave it for. But again, he had to appoint an administrator. And so the administrator was the facilitator of the charity. We did have to do the FRIPTA withholding, the 10%, and issue to the IRS that 10%. The big thing about this one was that a couple of weeks later, he called and said, well, how do I get that money? And you have to file your taxes. That's a whole different, another story, but you have to file the taxes and call the IRS. So if you ever take a listing that is FRIPTA involved transaction, make sure you educate your seller or the state on how to get that 10% once the funds are distributed. So that was the moral of that story. I did have a transaction where the mom owned the property free and clear, passed away, and she owed $100,000 to the IRS. So that's still, you still have to pay your taxes. There was a $100,000 IRS lien, and we had to distribute that out. That one was kind of interesting because they awarded, I don't know if she had any cash, but she owned the property free and clear. So this one, the probate was already done. The estate had done their final distributions and their settlement, and they still didn't have the IRS actually paid through her estate. So I don't think she actually had that much cash on hand. And so we still had to pay that IRS. And so that also goes into the correct orders to pass title. Some people are like, hey, this is great. This is what I have. This is what the attorney gave me. And I execute a deed to myself, from the estate to myself. And everybody thinks everything's done, but there's still one more document that's needed. And we had to go back to the attorney to get the correct letters of administration to pass on title. Just because the attorney has done their job doesn't mean that title is actually going to pass on something, because the attorneys are not title insurance insurers. So we just need to make sure that when you do get a transaction where title was already transferred via a probate order, then we want to make sure, again, that it has been done correctly. So ask questions when you get those listing agreements, look at your deeds, and make sure that the previous owner who transferred title, how was it transferred title? Was it through a title company? Was it through individuals? Or was it through a court? So always ask the questions. We had a probate case where I just mentioned the property. He had 5 properties. He actually passed away in Thailand. We had to get the death certificate transcribed. Imagine if that was happening now, how long that would have taken. We had to have his mom, who actually, his brother, who was in Canada, was the original heir, because he did have a will executor. But his brother seemed to vanish when he realized that he wasn't getting the property as the properties that he thought. So then we had to have his mom actually be the executor. She was in Canada for 9 months and hadn't actually had properly buried her son yet and grieved her son. But she was in Canada for 9 months before these all the transactions were closed. It was kind of crazy, because she was getting the last one that we had to do, that we were getting ready to close. She wanted to be back in Thailand by September, and we closed in August. So it can be done. It may take a minute. And then we had a deed upon death where the mom left the property, deeded the property using the deed upon death to one of the heirs or beneficiary. There were 4 other siblings, and we had to have all the siblings who were scattered across the country execute all the documents, and then we had to disperse to each of the heirs. After we had to have the underwriter's approval, and they provided me with all the documents that we spoke of earlier. And then I just did one where the court order did not arrive in a timely manner. The buyer was getting a loan. Buyer, of course, was going on vacation, needed the transaction closed. The attorney took 2 weeks to provide me with the court order, which I thought was kind of odd, because my attorney that I normally deal with, I get the court order on the day of the actual confirming the sale. But this court order didn't arrive until 2 weeks later. So here's the buyer, knowing that the order was confirmed on the Friday, wanting the documents on that Monday, wanting to close by that Wednesday, and 2 weeks later, we finally closed. So that was kind of stressful. So plan for that. Plan for not everybody closing quickly. And I think that's it. Do you guys have any questions? I hope you found it informative, and Adrienne has all the flyers that she can get out to you. If you have any questions, you can always call or email or text. I'm here.
Awesome.
Thank
Yes.
you very much. It was very informative.
Good.
That was a great class, Jennifer. Seriously, like, you hit on point on everything. And also talking about that deed upon death, like, that was great. Great information. Like, You're awesome.
Thank you.
It's all that experience, and that's why I use you, is because you have all that knowledge, all that information, and the experience of dealing with all these situations. And I think for me, being a realtor, you telling the stories actually helps prevent me from getting in trouble, I think.
Stay out of trouble.
Learning from other people's mistakes. So
Yeah.
you taking the time to educate us about this. Great presentation. Yeah, great job. So everyone, thank you so much for watching our video. If you have any questions in regards to the probate process, please don't hesitate to reach out. I'll leave my contact information below. So if you have any questions, you could reach out to us. And just remember, we're all in this together. This is kind of the new way of learning. And so I'm so excited about coming to you guys online. You guys could watch and learn about real estate right in the comfort of your own home.
I like that. So thank you guys. Have a great day. Call us if you have any questions. Call Erica, and then she will reach out to me.
Yeah, and we look forward to seeing you guys in another episode. Have a great day. Bye.